Speaker of the National Assembly.
On the 9th of February 2023, the President of the Republic of South Africa, President Cyril Ramaphosa, was required to present his State of the Nation address. The commencement of the President's address was met with various points of orders that were subsequently rejected by the then Speaker of the National Assembly, Nosiviwe Mapisa-Nqakula.
I will not entertain spurious points of order.
It eventually led to the Speaker ordering the Sergeant-at-Arms to approach the MPs to vacate the House. As the members were about to leave the House, 6 of the MPs alighted the stage. Members of the security forces and the Parliamentary Protection Services moved onto the stage to remove them from the House. The group was charged and later found in contempt, which was followed by a sanction of a 30-day suspension without pay. And they were further required to apologize to the Speaker, the President, and the people of South Africa. The group then turned to the Western Cape High Court to challenge their suspension and sanction, as well as the National Assembly rules governing the disciplining of members of Parliament. The EFF MPs contended that the rules provide the committee with wide powers and discretion without putting in place safeguards to guard against arbitrariness, partiality, bias, and abuse. The group added that the current rules permit a process that is unreasonable, procedurally unfair, and vulnerable to majoritarian abuse.
What we know from the authorities around the fettering of discretion is it depends on the nature of the power that's being exercised and the kind of consideration that the decision maker has to make. It could be examples of seriousness. It doesn't have to be X, Y, or Z offences, and that's the point. In the absence of guidelines to otherwise qualify what might be serious is open to abuse.
In a unanimous judgment, the full bench of the Western Cape High Court held a different view. The court, in response to the majoritarianism notion and the submission that the process is open to abuse, found that there was no basis by which to find that an independent third party, such as a senior legal practitioner or judge, as advanced by the applicant, should be involved in the process of disciplining members of Parliament. 2, the court also concluded that the committee's process and conduct was not unlawful, adding that the procedural grounds that form the basis of the applicant's review all stand to be dismissed, either on the basis of absence of legal justification or the very conduct of the applicants. As a result, the application was dismissed. Kani Mapanga, SABC News, Johannesburg.